very honored and grateful to the International Internship University and the doctors Supraya Kumarabelan and Ermina Raescu. In this opportunity, I talk about the conventional law, constitutional law, and fundamental rights. The materialization of the validity and conventionality is a gradual acceptance and application by the signatories states of American Convention of Human Rights constitutes a transcendental advance towards the legitimacy of the legal systems of the world. They requires an analysis of its concurrent or current performance and its close relationship with the performance of constitutional law and fundamental rights. Second place, Inter-American System for the Protection of Human Rights. Its international system agreed upon by the states of the Inter-American System with the proposed establishing common minimum standards of terms of respect, guarantee and adequacy of the national legal system as conventionality established in the American Convention on Human Rights. The state parties have also agreed to establish a system for monitoring compliance with these standards through two bodies, the American Commission or Inter-American Commission of Human Rights and the Inter-American Court of Human Rights. And the latter, it's a binding jurisdiction for the state parties of last instance and inappellable, whose judgments constitute obligations of result which are not subject to any appeal. The jurisdiction maintains oversight of compliance with the judgments until the respective state party compliance with all measure of reparation determined by the court. This is the object and purpose of the Inter-American human rights system. Therefore, the development of this system consolidates the scope and jurisdiction with the never so visible validity of the conventional law. It's worth saving, by the way, that it's later it's in a phase of healthy protagonism and transcendence, expanding the vision of constitutional law legitimized in the interworld. However, this entails analyze the scope of the control examination of conventionality, the effects produced in this respect, as well as the international or internal and external compliance by the state. Conventionality that submits to the constitutionality. The four final and transitory provision of the Peruvian Constitution reward the interpretation of fundamental rights states. The norms relates to the rights and the freedoms recognized by the constitution are interpreted in accordance with the Universal Declaration of Human Rights and with the international treaties and agreement on the same matters ratified by Peru. The American Convention of Human Rights, also known as the Pact of San Jose de Costa Rica, which is a part of the Inter-American System for the promotion and the protection of human rights, was ratified by the Peruvian state, as well as the Peruvian state. More than 20 countries have signed it, namely to date, nations have adhered to the convention. For example, Argentina, Barbados, Bolivia, Brazil, Colombia, Costa Rica, Chile, Dominicana, Ecuador, El Salvador, Granada, Guatemala, Haití, Honduras, Guatemala, digo Jamaica, México, Nicaragua, Panamá, Paraguay, Perú, Suriname, Trinidad y Tobago, Uruguay, among others. Consequently, these states submit to the interpretation of the rights and freedoms that the political constitution recognizes in accordance with the provisions of the American Conventions of Human Rights. In turn, Article 1, Paragraph 1 of the American Convention of Human Rights regard the obligation, the respect rights, states. The states parties to this convention undertake to respect the rights and freedoms recognized here and ensure to all persons subject to the jurisdiction to free and full exercise of those rights and freedoms. Conventionality from the beginning. The name conventionality control is relatively new. It has European antecedents dating back to the 70s of the last century, but in our America, Stephen, it was only established in the 2006. In the famous case, the Almonacid Arellano versus Chile, where the plenary of the Inter-American Court of Human Rights is the case. The first to put forward the thesis in the Inter-American judicial space was Judge Sergio Garcia Ramirez, an accredited Mexican jurist whose beginnings were in the criminal discipline, but who has later dedicated himself persistently to the subject of the human rights, both of the local and the inter-American level. Thus, the judiciary must exercise a kind of conventionality control between the domestic level norms that apply in a specific case and the American Convention on the Human Rights. In this task, the judiciary must take into account not only the theory, but also the interpretation made up way the Inter-American Court, the ultimate interpretation of the American Convention in this sense, case of the La Cantuta versus Peru, merits reparations and cost is other example. Furthermore, the ordinary and constitutional courts, it's as agents of the state, are the prior to the exhaustives of domestic remedies, having the competence to their remedy and violation of internationally recognized human rights before a case is brought before the international instance. Judge as those the primary operators of the principle of subsidiarity inherent and international human rights law begin called upon to apply the control of constitutional or conventionality as determined by the Inter-American Court or the human rights. The constitutional opening to the international conventionality or conventional human rights law also requires ordinary and constitutional judge open to new alternatives of interpretation that make the assurance and guarantee of rights a reality for the benefit of the holders and fundamental rights. It's also wrong nothing the provisions of Article 25, paragraphs 1 and 2, respectively, of the aforementioned convention, which in relation to judicial protection establishes that everyone has the to simple and prompt recourse or any other effective recourse to the competent court or tribunal for protection against acts that violate his fundamental rights recognized by the constitutional or laws of the state concerned or by this convention. Even though such violation may have been committed by persons acting in the course of their official duties, and the state party undertake to ensure that the competent authority provide for by the legal system or the state shall decide on this in the rights of any person claiming such a remedy. To the develop the possibilities judicial remedy and the ensure the enforcement by the competent authorities for any decision guaranteed such a remedy. For other side, types of judgments to apply conventionality. In this case, we have three types the judgments to apply the conventionality. In principle, in first time, interpretative rulings in accordance with the conventionality parameter. By the presuming the conformity of the equation of the norms, provision of acts subject to domestic public with law with the conventionality parameter, constitutional judge must make an effort to save their conventionality validity, making interpretation in accordance with the conventionality parameter, avoiding the annulment, an expulsion for the norm from the legal system. It is therefore an effort to harmonize the national norm with the parameter of conventionality. Second time, we have declaratory of inconstitutionality. In this case, with the norm or provision is absolutely and directly incompatible or not in conforming with the conventionality parameter. The constitutional judge has not other opinion but to issue an affirmative judgment declaring the norm or convenient to be unconstitutional. In third place, we have dismissal of inconstitutionality. In this case, when the respective constitutional court or chamber considers that the local rule or provision is in the line with the conventionality parameter, must so declare it. Of course, this type of judgment might eventually expose the respective state to international responsibility and face a case before the Inter-American Court, since the interest party may consider that the judgment is erroneous and will therefore seek to have that regional jurisdictional body exercise the concentrated control of conventionality, especially if the constitutional jurisprudence is binding erga omnes and has the status of the legal norm. When the norm or provision is absolutely directly incompatible of norm in conformity with the conventionality parameter, the constitutional judge has no other option but to issue an affirmative judge declaring is or conventional of the legal system. For other side, advisory opinions are also binding. In this case, the advisory opinions on laws and bills have binding effects for the required states of the states that have ratified the convention of the instruments del System International de Protection of the Human Rights. The judgment, this system, the court, have the effect, the res judicata for the state involved in the contention process, and the res judicata and have accepted the continuous jurisdiction for the system law on the court. The declaration, the inconstitutionality of a norm by the system court does not imply its automatic annulment, repeal, or loss of validity. Since the system court is not a supraconstitutional court, and the jurisdictional of subsidiary, in this case, the power to create norms, reinterpret them, annul them, or apply them remains an exclusive power to the state. The system court forwards its decision to the commended state, so what it may take the necessary measures to adapt its domestic law to the standards the system international or inter-American protections, the right right laws. No, for other case, we have the troubles in the application of the control of conventionality. The fact that a judgment of the system court should be applied, the respondent state should make its own. This means that sometimes it's necessary to archive judicial cases and open new proceedings with the complications that this entails. In other words, a new trial which the law that was questioned will not be applied, but rather that principles derived from the inter-American judgment, and will the possibility that the trial in the end exceeds the reasonable term that the court itself has taken great care to square and reaffirm. For a time, another point that has arisen that the judgment is not limiting the specific case. The court considers that its decision can or should be applying in all similar case or situations. And if, for example, we can before the court was a process involving 20 persons, even the only thing had been involved, the principles of the judgment uses in a process in which they did not participate and to which they must submit themselves should also be applied to those who did not participate. The judgment thus acquires an expansive character that is to say applicable to all those involved, even if they have not appeared before the court. This indubitability affected the rights of defense. And and if this were not enough, it's to be considered that the control of conventionality is borne by decision of the Inter-American Court. It's applied in that venue only to the specific case. It's then extended to similar case when they have not been heard by the court. Ex officio, a national judge must apply the norms of the Pact of San Jose de Costa Rica as well as the jurisprudence of the court in the case they hear, and the judge must bear in mind when ruling on the case, submitting to term the American human rights norms, even when the Inter-American courts has never issued any pronouncement on what they must resolve. Next, we have the stage in the evolution of law in the world, of the world. In principle, we have the state of nature, second, rule of law, second, third, a continuation, constitutional rule of law, conventional rule of law, restorative rule of law, and finally, a state of justice. For other sides, we have the objections of the inter-American system for the protection of human rights. In this sense, the Inter-American Court of the Human Rights has exaggeratedly long deadlines for the issuance into the advisory opinions, judgment, and resolutions, which can even take the 20 years approximately, 20 years, to which be must an average of 10 years for the same party to comply with the provisional of the same. And finally, at the latest 10 years additionals for the case exhaustion of domestic jurisdiction in order to be expected to be heard to be for a foreign nationality court. Thus, it can be seen that the sum of the years is very worrisome, since it takes an average of 40 years for the court's decisions to finally become effective, materialized basically. This, in addition, violate the fundamental rights that the court itself and the state's party and responsibility for violation of the course of the period. Therefore, this is an additional reason why the control of the conventionality does not meet the objectives set forth in this quintessence, since the remedy ends being perhaps worse than the dislikes. Conventionality has raised the what in the acceptance method, but has lost in was in the how. Therefore, also does not deserve in any way to be equated to nature of justice. Ergo, in merit of what has been sustained in this it is demonstrate that the examination of conventionality is not the panacea to justice. Science is the below even restorative justice. Thus, the review of conventionality is not the light, the oracle, the lace of the line, and by the way, we maintain that the only thing equal or comparative of justice is the last stage refer to the stage or state of justice. Degree, for other time, we have degree of justice offered to the system, internationality, the protection of the human rights. Apparently, the nature, the system presents a much higher level of protection of safeguarding of fundamental rights. Let us say that it is comparable to the definition of the so longed for or longed for justice. in principle, as we pointed out at the beginning of this article, it should be reiterated that the Inter-American system for the protection of human rights constitutes, and the Inter-American system agree upon, but the state of the Inter-American system with the proposed of established common minimum standards in terms of respect, guarantee on adequacy of the national legal systems conventionality established in American conventionality of human rights. Obviously, it will take centuries or perhaps millennia of the state of justice to become a reality. However, this does not prove to be an obstacle for the actors, for the justice administration system to decide, to assume the challenge and decision in the terms of justice, but virtue of the principle of legitimacy. Since this is what the justiciable deserves and demands exclusivity and with just right. For all time, we have from the constitutional state to the conventional state of law. We have the one scenario, second scenario. The constitutional state to the conventional state. And decent presupposition of the constitutional state of law. The constitutional scene is a relative document of the legal system. Hence, this state scheme is colloquially identified with the phenomenon of the constitutionalization of the legal system. Good analysis requires citing to the production of Riccardo Guastini, Italian jurist, who in the reward provide the elements of the phenomenon and consequently the structural characteristics of the constitutional state, which in order are existing size of the rated constitution, jurisdictional guarantee of the constitution, direct application of the Constitution, binding force of the Constitution, over interpretation of the Constitution, interpretation in accordance with the Constitution, influence to the Constitution in the political debate, and a last element proposed by Professor Celestino del Arenal, which is circularity and normative integration. It's understood that the conventionalization for law is a process in which the law of ability, the external laws or norms express the convention and theories which make up an international legal system with binding effects, whose purpose is safeguard and obtain an effective protection of rights and freedoms. This is operational state through the control of conventionality by means of which, in the event of the conflict between a rule of domestic and the international rule, the latter will prevail, not applying, deforming or failing that it will be giving an interpretative content in accordance with these international rules. It tells that it's not only a sequential logic and origin tracing from the constitutional rule of law to the constitutional rule of law, the constitutional rule of law to the conventional rule of law, and this in an objective, normative, and forceful manner. On other sides, we have submissions substitutions of the conventional rule of law. It's understood that conventionalization of law, it's a process in which the law of a state as a system integral or integral internal legal system has its source of inspiration, creation, and validity. The external laws or norms expresses to the conventions and theaters which make up the internal legal system with binding effects, whose purpose is the safeguard and obtain effective protection of rights and freedoms. This is operationalized through the control of conventionality by means of which in the event for the conflict between a rule of domestic law and the international law rule. The latter will prevail, not applying the former of finding that it will be giving an interpretive content in accordance with these international rules. Taking is a basic, but what was seen jurist Italian state above for the constitutional rule of law. We maintain among the constitutional elements for the conventional rule law. We have existence for the reading of the rigid conventionality, jurisdictionality guarantee or conventionality, binding force or conventionality over interpretation of conventionality, interpretation in accordance with the conventionality control, influence of conventionality in the political debate, circularity and normative integration, and internal and external diffuse application on conventionality. Finally, in this opportunity, we talk the interdisciplinarity. In this case, we have points developed not as summer basic in the regional Latin American, not assume or do not end to being as expected. These points turns out to be of particular importance and transcendence since in principle has been possible to observe the existence of a series of situations that arise in a systematic way, whether in a erratic, incomplete, thoughtless, illegal, unconstitutional manner. This will be due to the arguments that they will now develop. Next, it goes without saying to the need not concern ourselves with answering the basilar questions to the fall on propose. It's the responsibility of legislator, which is such an action, a constant and everything we wish to carry out. Why it's too alien and erratic the company and question can be to us, why does it taking or can it take so along the achievement that we are supposedly seeking and must seek without actuality achieved? Why the parties and the administration have to suffer too much before they can embrace a more equality treatment in the recognition of their fundamental rights? Why is not too clear to begin with? Finally, why does it not happen in Europe and here in Latin America? For example, it does. In its order, the trouble we can rehearse and resolution to the questions, blaming nothing less than results of nature of the kind of our Latin DNA. Thus, the answer seems the point to every deep reasons, to our construction, to something that we sample cannot avoid, since it's part of our own nature. Thus, analyzing in depth, or perhaps reality of deep, we have to point out that this inability to reflect which characteristics as Weather says, is not a product of change, but of casualty. Thus, we have to take account that as Peruvians, for example, in presenting men's, we present in men's factors since we did not have the renaissances or angel intelligence age, the humanity, or the evolution. We jumped with the pole from the ancient or the age initial for the modern age. In this sense, we lack the ability to reflect, really to think from oneself and one's environment of simple be reborn, as well as the laws of fate in all kinds of dogmas which the Renaissance gave to Europe in the 11th, the 15th, 6th centuries. This is the explanation. This is the explanation for our great kings. Then in the light for the Western Peruvian shortcomings described above. It goes without saying, to quote Ortega y Gasset, man is not such, but he and his circumstances, to take into account that everything that apparent to us a culture brought result what has been pointed out, which cannot to save and ignore it just like that. Thank you for your attention. Thank you very much.